Separation and pets, what the 2025 changes mean for you. Hi everyone, I'm Nadine Udorovic. I'm a principal lawyer here at Nichols Family Lawyers with offices in the Melbourne CBD and Geelong. I've just had a couple of days out of the office to spend with my kids over the school holidays, and of course that meant I got to hang out with my British Bulldog, Mr. Bluebell. Bluey is such an important part of our family, and a common question I get from my clients is, what happens to the family pet in the event of a separation? So given the significant role that pets play in family law, it is understandable that many people are concerned about their pets and the legal rights and entitlements when it comes to retaining them. So here's what you need to know. Until recently, the Family Law Act 1975 made no reference to pets or how they should be treated following separation. Instead, the Federal Circuit and Family Court of Australia regarded pets simply as property to be divided between the parties, much like furniture or a car. So if parties could not agree, they could apply to the court for an order dealing with the family pets as part of the financial settlement. In making a decision, the court typically considered who purchased and initially registered the pet, whether that was at the local council, the vet or the Central Animal Records, whose name the pet was registered under, who was the pet's primary caregiver, who paid for their food, their veterinary bills, their grooming and other expenses, and each party's lifestyle and capacity to care for the pet. So this approach meant that little if any regard was given to the animal's welfare or the emotional bond between the pet and family members. And for those of you who have pets, we know that that's such an integral part of owning a pet. So this all changed with the passing of the Family Law Amendment Act 2024, which introduced amendments to the Act that came into effect as of 10 June 2025. And pets are now legally recognised as companion animals, a distinct category of property. So companion animal is defined as an animal kept by one or both parties to a relationship, primarily for companionship. However, certain animals are excluded from this definition, including assistance animals, so those trained to support a person with a disability. And it's timely as well. I've got our little court dog, guide dog, little puppies here, who are very, very cute. Animals kept for business purposes, animals used for agricultural purposes, and animals involved in laboratory testing or experiments. While still treated as an asset within the property settlement, the amendments required the court to consider a broader range of factors relating to the pet, including how the companion animal was acquired, for example, purchase price or whether it was a gift, the legal ownership and possession, including registration details and living arrangements since the date of separation, each party's contribution to the pet's care and expenses, for example, food, vet bills, grooming, training and exercise, any history of family violence, including where pets have been abused, injured or used as a tool of coercion and control, the emotional attachment to a party or a child to the pet, particularly where the pet provides comfort and support to a victim survivor of family violence, each party's demonstrated ability to independently care for the animal financially and practically, and any other relevant factor to achieving a just and equitable outcome. And these amendments reflect a shift in societal attitudes towards domestic pets, recognising their role as valued family members. So what does this mean for separating families? So the Federal Circuit and Family Court now has the power to not only make orders clarifying who owns the pet, but also has the power to transfer ownership or to order the companion animal to be sold. So additionally, the court cannot order joint ownership of a companion animal. So for example, like in parenting cases where we have orders for shared care or parenting arrangements for children, we cannot have similar orders for pets. So the court is not obligated to make any order relating to the family pet if doing so would not be just and equitable. The court will be more willing to make orders relating to pets, and now that they are defined within the legislation. And certainly I've seen a couple of those cases more recently. Whereas previously they were not inclined to do so. So if you are going through a separation and need guidance about your pet's future, please do not hesitate to contact us here at Nichols Family Lawyers. We understand the central roles that pets, our furry babies, play in family life and are here to assist you.